Get ready for the dictation in 3, 2, 1, start. In view of these facts, the amount to be deposited by the petitioner before CES TAT New Delhi in their statutory appeal under the Customs Act 1962 comes to rupees 4.23 crores for one appeal, which is 0.0705% to the total turnover. Hence, we see no reason to entertain this writ petition looking to the total turnover of the petitioner as well. Much has been argued out by the counsel for the petitioner, relying on several annexures, including Annexure P1, that there are several non-registered online health service aggregators operating in the field in Delhi and that their activities must be stopped by the respondents in accordance with law. Having heard the learned counsel for both the sides and looking to the facts and circumstances of the case, we hereby direct the concerned respondent authorities to initiate action in accordance with law against any illegal online health service aggregators operating in Delhi in violation of the application law, including the Clinical Establishment Registration and Regulations Act 2010, if applicable, or in violation of any rules, regulations, or government policies applicable to the facts of the case. Action will be initiated in accordance with law against such violators of the law as expeditiously as possible and practicable after giving an adequate opportunity of being heard to the concerned parties. Several examples have been given in this writ petition about such alleged violators. Since they are not joined as party respondents, we are not observing anything against any of the parties or so-called violators of the law. As pointed out in the writ petition, it is open for the respondents to take action against any such violators of the law as stated herein above after giving an adequate opportunity of being heard to the concerned parties. With these observations, the writ petition is disposed of. This review petition has been preferred by the original writ petitioner seeking review of the order passed by this court in WPC number 4695/2020, which was preferred as a PIL for the benefit of advocates. The writ petition was dismissed vide our order dated 29th July 2020. Having heard the petitioner in person and looking to the facts and circumstances of the case, we see no reason to entertain this review petition, mainly for the reason that there is no error apparent on the face of the record in our order dated 29th July 2020. Much has been argued out by the review applicant party in person about the previous orders wherein notices have been issued by this court in matters pertaining to creation of the post of Advocate General in Delhi, selection process for the students, etc., which are annexed as annexures to the memo of the review petition. We have perused those annexures. The present case is a PIL preferred by the party in person for including advocates in the definition of the word professional under the Micro, Small and Medium Enterprises Development Act 2006. We are of the view that the advocates are capable of filing their own litigation if they wish to do so. On this point itself, we have dismissed the writ petition as a PIL. In the case of Meera Bhanja versus Nirmala Kumari Chaudhary, reported in 1995, 1 SCC 170, the Honorable Supreme Court at para 8 and 9 held as under. It is well settled that the review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1 CPC. In connection with the limitation of the powers of the court under Order 47, Rule 1, while dealing with similar jurisdiction available to the High Court while seeking to review the orders under Article 226 of the Constitution of India. Stop. Thank you.